Good day, Crime Talk aficionados. This is Scott Reisch with Crime Talk, and thanks for watching. We have a big docket today, so let's get right to it. First, a lawyer forges the signature of a judge and a prosecutor. Is that wrong or something? Second, don't mess with Texas. Third, a career politician who is a crook. Imagine that. Fourth, authorities know who shot the federal judge's husband and killed her son. No suspects in the fishing trip turned into a triple homicide. The McCluskeys are getting charged. Actor Johnny Ortiz charged with attempted murder, and our dumb criminal contestant of the day. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch with Crime Talk. Thanks for watching. We know you have lots of things you could be doing. We're glad that you're with us. If you haven't done so already, please hit that like button, hit that subscribe button, and that little bell so that you receive notifications of when we put up new content or go live like we'll be doing tonight at 6 p.m. Mountain Time, both here on YouTube as well as Facebook. First on the docket, a Georgia lawyer has forged the signatures of a judge and a prosecutor. Is that wrong or something? Yes, it is. It is very, very wrong. And Jake York, the attorney at issue, is going to have some real difficulties keeping his law license, or at least he should, because he exercised some really poor judgment. Apparently, Mr. York represented a woman on a stalking charge. He believed that the case was going to go away, and he wanted a modification of the pretrial release, which included an ankle monitor, which cost almost $400 a week to have on as a condition of the bond. Apparently, Mr. York spoke with the district attorney. The district attorney did not agree to any bond modifications, nor did the judge ever recall signing the order. That's right. Apparently, the client went to get her ankle monitor removed, and a little investigation, which didn't take a whole lot of work, determined that the ankle monitor order had never been signed. The district attorney moved to vacate that order, stating that they had never signed it on behalf of the district attorney's office. The judge then held a conference call with Mr. York, the district attorney, and herself. The judge said, "This doesn't appear to be my signature. And oh, by the way, I always sign it with a date next to my signature. And on this particular date, I wasn't even in the circuit. She was in Atlanta." Apparently, Mr. York said, "Well, I may have simply signed the DA's signature because I thought it was a done deal." Not a good move. And on top of that, both the judge and the district attorney stated that they were going to refer this matter to the Bar Association for disciplinary action. On top of that, Mr. York has been charged with 2 counts of forgery. Mr. York, bad decision. Now, this is a classic example. If someone should go to jail, always let it be the client. And second, no one has paid me enough money ever to jeopardize my law license. If Mr. York's client could not afford the cost of the ankle monitor, I can tell you I've never seen anybody go to jail for not paying their ankle monitor, particularly if they have an inability to pay, i.e., they're indigent, they're poor, they can't afford it on top of living. Not going to happen. Second of all, but even if that were the case, the attorney can do no good if he is in custody and cannot represent his client and has no law license. Ultimately, I have never been paid enough money to jeopardize my law license. I've had several clients that I liked. I really thought they were a very good person, but I would never, ever do anything that would jeopardize my law license for them. Mr. York violated 2 fundamental principles right there. Next on the docket, don't mess with Texas. That's right. The Texas Supreme Court reminds cities there's no pandemic exception to the Constitution. 4 justices on the Texas Supreme Court fired a shot across the bow of government officials continuing draconian COVID-19 restrictions in Texas. In a concurring opinion, Justices Blacklock, Guzman, Boyd, and Devine reminded everyone that the Constitution is not suspended when the government declares an emergency or state of disaster. The court stated, as more becomes known about the threat, about the less restrictive, more targeted ways to respond to it, the opinion continued, burdens on constitutional liberties may not survive judicial scrutiny. This opinion was a message. The Constitution still applies, and the courts will enforce it. The court was basically letting all the politicians know that this is Constitutional Law 101, because it appears that many government agencies need a refresher course. This case in Texas, the court actually declined to hear the case because the relief sought by the petitioner was not within the court's jurisdiction. However, the court said that these matters can still stand up to judicial scrutiny and they'll have to be tested. The courts in Texas also noted that the only person or entity that can suspend laws in the state of Texas are the legislature. The courts let everyone know that the governor's mandates to shut certain businesses and to suspend certain laws in light of the COVID-19 crisis may not, in fact, be constitutional because the governor doesn't have that authority. Now, I've been saying this from day one. The governors have limited authority. Executive orders are policy decisions. And to one day say that they can simply change the law at a stroke of their own pen is unconstitutional. And if you notice these actions that are being enforced, when the governor says you're violating a provision, they're using other laws. They aren't saying that you are violating the governor's executive order. They send in the individuals from these bureaucratic organizations under the control of the governor's office and say, we're going to shut you down for some other offense, not violation of the executive order. We'll see how these play out. Now, courts a long history have said that no doctrine involving pernicious consequences was ever invented by the wit of man, that any of its provisions can be suspended during any of the great exigencies of government. What does that really mean? It means that the government cannot suspend fundamental rights, and that the burden is on the government to explain why the restrictions are necessary. A lot of people cite to the 1905 Jacobson versus Massachusetts opinion, which held that a state and local governments have broad constitutional authority to adopt rational public health measures like vaccinations. But Jacobson dealt with whether government had the authority to enact public health measures at all. The court in Jacobson explicitly left open the possibility that such health measures could run afoul of the Constitution if they restricted fundamental rights like freedom of assembly or the right to private property. The court in the Jacobson decision further noted that it had a duty to examine the record to ensure that government's claims of emergency powers were legitimate. If health regulations went beyond the necessity of the case and under the guise of exerting a police power, violated rights secured by the Constitution, the court could be bound to hold such laws invalid. In other words, even though Jacobson does not create the pandemic exception to the Constitution that some actually believe that it does. Now, of course, saying that the Constitution still applies in a pandemic doesn't mean that the government can do nothing to fight, for example, the COVID-19 pandemic. It simply means that when the fundamental rights are infringed, it is the government, not citizens exercising their liberties, that bears the burden of establishing that the restriction is necessary. As the 4 Texas Supreme Court justices noted, any government that has made the grave decision to suspend the liberties of a free people during a health emergency should welcome the opportunity to demonstrate, both to the citizens and to the court, its necessity. As things go on, this is certainly going to be met with lots of litigation in the courts, and probably ultimately it will go to the United States Supreme Court, where the real issue, I think, is going to lie is if it is determined that these agencies or these governmental agencies, the governors, did not have the authority and basically destroyed millions of people's livelihood and their businesses, that potentially they may have committed a taking, and there may be financial obligations that need to be paid to these business owners that have lost everything. We'll see how that ultimately shakes out. Everyone needs to do the right thing. They're saying today, wear a mask, even though 3 months ago, wearing a mask wasn't a good thing. You should probably wear the mask. And if you are going to wear a mask, you should probably wear a Crime Talk mask. So go to the link below, go to Teespring, and get yourself a Crime Talk mask. Not only will you look good, you may be helping yourself and those around you from getting sick. Next on the docket, a career politician was a crook. Can you imagine such a thing? Oh my gosh. That's right. The ex-New York State Assemblyman Speaker was finally sentenced to 6.5 years on public corruption charges. And I mean finally. Sheldon Silver, the former Speaker of the New York Assembly, will finally have to go to jail. Why, you say? That's right, because his 2 previous convictions were reversed because of a change in the law by the United States Supreme Court. And in both circumstances, that's right, the citizens of the state of New York said, Sheldon Silver, you are a crook. And finally, after years and years of delay, he is in prison. The judge didn't grant a stay. The judge did not say, Mr. Silver, you lived such a good life. I'm going to give you in-home detention. No, the judge said, the time has come and it's long overdue. The judge says this was corruption, pure and simple. And the court also noted that this 78-month sentence was meant to be a message to the people in the Albany State House to deter others from the conduct that Mr. Silver engaged in, which was basically a kickback scheme that went on for decades. Can you imagine someone getting rich in public office when they're making a paltry salary of a public servant? That's right. If you go into office and you get rich, it should be per se criminal conduct. Public service, like being a public official, should be that, public service. When I have clients that go do public service, they don't get paid for it. They have to pay for the workers' compensation insurance to do that. So maybe our elected officials should work for maybe $1, and they should have to take out insurance for any misconduct that they actually commit while in public office, even though we all know they have immunity, except when you break the law. Now, Mr. Silver, who completely denied any wrongdoing, apparently finally realizing that he was in fact going to go to prison, made a statement in allocution. And that's the right of every criminal defendant to kind of get the last word in after both his attorney and the prosecution has spoken. And he seemed to adopt the words of the United States attorney in this case, because he stated that the actions were a sense of entitlement and a loss of perspective. That apparently he lost this perspective after being in office for 2 decades. He stated, "My use of my office for personal gain was improper, selfish, and deeply unethical," Silver stated in his final remarks to the court. "I want to be clear that what I did was wrong." Well, apparently he only wanted to admit that those actions were wrong once he was actually going to prison, because before that, he was claiming he did nothing wrong. So I'm kind of confused as to why Mr. Silver had the epiphany. Perhaps it's because he's not in good health and he will probably die in prison. Probably not the legacy he was looking forward to when he held that position for some 2 decades. Now, ladies and gentlemen, the last story that we talked about showed basically how all the constituents of Mr. Silver in the state of New York could be fooled by somebody. And the entire legislature, the state was fooled for 2 decades that this person was in fact a crook. All right. So how do you know if you're going to be dealing with people that are crooks? Well, you can get as much information as you can about them. How are you going to do that? Go to CrimeTalkSearch.com, sign up for a subscription for a background service. All right. There is a fee, but there's a no-risk trial in the sense that you can cancel at any time. And when you sign up for the subscription, you can search as many people as you want. And the beautiful thing is you get to do it anonymously. And when you search and you get this report, you can search and find out what social media that these individuals may have. You can search to get phone numbers, email contacts. You get a report relating to criminal records based upon, for example, criminal convictions, as well as sex offender registry. You can look into bankruptcies. You can look to see if there are any civil judgments. You can look into property records as well as marriage records. These are all the types of things that you would want to know about a person if you were getting to know them. Don't be fooled. Now, we have put up several unsolicited responses that we've received from subscribers who have both said they thought they were going to get involved romantically with an individual. They did a background search and they found out that the person that they were dealing with was not the people that they thought they were in fact dealing with. One had a conviction. The other one didn't even live in this country and was telling nothing but lies. Wouldn't you like to know that information sooner rather than later? Well, those individuals certainly did. Go to CrimeTalkSearch.com, sign up for a background subscription today. You'll be glad you did. Next on the docket, authorities now believe they know who shot the federal judge's husband and killed her son on Sunday at her residence. The person who went to Judge Salas' home dressed in a FedEx uniform was actually an attorney by the name of Roy Hollander. And Roy Hollander apparently was also threatening New York State Chief Judge Janet DeFore. Now, we know that Hollander appeared in front of Judge Salas relating to a lawsuit that was filed where he challenged the draft applying to women. Apparently, Mr. Hollander has some very outdated beliefs and somewhat misogynistic beliefs that women should either not serve, and basically, let's face it, Hollander has some mommy issues he needs to work through. Apparently, he hates women. He had nothing good to say about Judge Salas other than he thought maybe he wanted to date her during the first interaction that he had with her. However, he then basically said that she was not qualified and didn't deserve to be on the federal bench, most of it because of her gender. So Mr. Hollander clearly has some very outdated beliefs, and the fact that he would go kill people that he does not like while he has recently been diagnosed with cancer and was going to be dying, this is certainly not the way to handle it. He is clearly nothing but a coward. There's also information that Mr. Hollander may be related to the death of an attorney in California as well. So this may take a little time to unravel, but clearly don't go around shooting people that you disagree with. It's just not right. I don't understand how anybody could think that that would be a good thing to do. Yesterday, we brought you the story of the 3 men that were going on a fishing trip overnight in Florida, and all 3 wound up dead. Basically, 2 gentlemen were going to a fishing spot to do a little camping, and another gentleman was arriving later. Upon the 3rd gentleman's arrival at the location, apparently his 2 friends were being beaten and shot, as well as he would ultimately wind up in the same circumstance. The 3rd gentleman called his father, and the father ultimately called the police. When they got there, his son was hanging on, but ultimately passed away. The sheriff has said he has no suspects in this matter whatsoever. Apparently, this fishing spot is out kind of in the middle of nowhere. It's about a 3-mile drive. and literally no one would see it from a passing road. But apparently it's kind of a party location. People show up on Friday and Saturday night. They like to drink and smoke dope out there, according to the sheriff. We'll see how this unfolds, whether this was something completely random or if somebody knew who was going to be there and wanted to maybe resolve a beef with somebody. But bad situation. Be safe out there, people, particularly if you're going fishing in Florida. Next on the docket, Mark and Patricia McCluskey are being charged. That's right. They're going to be charged with a 4th-degree assault, a felony. Now remember, the McCluskeys sort of came to fame after a June 28th incident where protesters broke down a gate that was guarding a private community because the protesters wanted to go to the mayor's house and demanded that she defund the police. Well, the McCluskeys saw what was going on. Apparently, they went outside. The people began to threaten to kill the McCluskeys as well as to burn their house down and their dog. Now, this is according to the McCluskeys. At some point, the McCluskeys go and retrieve a handgun and an AR-15 rifle. According to St. Louis Circuit Attorney Kim Gardner, she apparently has 2 people that say that they felt threatened by the fact that a gun was pointed in their general direction. And those 2 individuals are identified only by their initials in the criminal complaint. Now, this may be somewhat of a political criminal prosecution, and the Attorney General has actually filed suit to have the case dismissed. And the governor of the state of Missouri has also stated that he would pardon the McCluskeys if they were ever charged with any alleged wrongdoing. I really can't believe that people have a problem with someone defending their property. If someone was threatening to burn your home down, do you think you would want to defend it? Do you think you would defend it? Or would you simply walk away and let an angry mob burn your house down that you apparently had worked for your entire life? My guess is most people are going to defend their property. And the firearm, which is a great equalizer when you have a large group of people yelling angry things at you, threatening to burn your house down, apparently stopped the angry mob with only 2 people and 2 firearms. And apparently the district attorney thinks that no one has a right to defend themselves or their property. Perhaps the voters in Kim Gardner's district would like to have her removed at the next election, or maybe a recall. Just saying. Ladies and gentlemen, the government, if you look at the Constitution, the government has restrictions on their power. Their job is to make sure that your rights are not infringed by other people. And if you're protecting your property, you have a right to do so. That is my opinion on this particular subject. Yes, I wish the McCluskeys had kept the guns pointed straight to the ground and there would be no issues as we sit here today. However, they did what they did. It's on video. Hopefully there'll be more video of the people breaking down the fence as well as vandalizing parts of the neighborhood as well. If the McCluskeys had contacted me, I would tell them one thing. I love firearms. I love the Second Amendment, but they complicate everything. And you can't go around doing anything because they do, in fact, complicate the situation. So you have to be smart about it. The McCluskeys, although I think they thought they were doing the right thing at the time, probably would, looking back in hindsight, the McCluskeys may want to handle the situation just a little differently if they had spoken to me. Let's just put it that way. Next on the docket, actor Johnny Ortiz has been charged with attempted murder. That's right. Apparently Ortiz, along with a co-defendant by the name of Armando Miguel Navarro, have been charged with the attempted murder of an individual by the name of Brian Duke. And apparently it was somehow in furtherance of a gang-related activity. Now, McFarland has played in El Camino, a Breaking Bad movie, as well as McFarland USA. He currently faces bail set at $1.1 million, and he has a preliminary hearing set for next week. We'll see how this shakes out. It's always a little disappointing when someone with so much potential gets involved in serious situations that will forever affect their future. Next on the docket, our dumb criminal contestant of the day. Walmart surveillance captured this woman going into a Walmart store, placing several electronic items in the cart, and then loading up a 65-inch Ultra HD television into a cart. Did she go straight to the checkout line in the electronics section? No. Did she go to the checkout line near the front of the store? No, she did not. No, this individual, who is yet to be identified, walked straight out the front door to a waiting car where a companion unloaded the other electronic devices. And unfortunately for them, or fortunately for them, they realized that the 65-inch TV was not going to fit in their car, and they had to abandon the television in the parking lot. This person is our dumb criminal contestant of the day. And why would they be the dumb criminal contestant of the day? Well, first of all, they're shoplifting. That's theft. Taking something of value from another person without their permission is shoplifting. Well, you say, Scott, but they returned it. They didn't take it. No, it's still theft. It's at the intent at the time of taking it that would make them guilty of this particular offense. Now, perhaps a little even more disturbing, if this person was a subscriber to Crime Talk, she would know the numerous times that we have talked about what the prosecution has to prove. And they have to prove identity. And how do people get around proving identity? We talked about it yesterday. Masks. They camouflage or disguise themselves. And this dumb criminal contestant of the day didn't even have a mask on in Walmart. So for that, she will be identified, and she is our dumb criminal contestant of the day. As we stated earlier today, we will be going live this evening at 6 p.m. Mountain Time. Immediately following that, we will go to our Crime Talk Patreon page. And so if you have not already signed up for that Patreon page, please do so today so that you can be sent the link to where to go to talk on the Patreon Crime Talk page. Thanks for watching. Have a great day. We'll see you tonight live at 6 p.m. Mountain Time. Have a great day.